May it please the court. Your Honors, my name is Charles Lincoln and I represent the State A Tax Authority, and our position is that we advise the court to render the CFC, Controlled Foreign Corporation regulation, as applicable to the dividend payments and not being in contradiction of the State A, State B treaty. There is sufficient evidence to support a prima facie valid tax assessment against the taxpayer applicable against companies A shareholding in State B in Company B because the Commissioner has demonstrated income were imputed as distributed from Company B to Company A. Under certain circumstances, an assessment may be valid via the State A, State B treaty, especially in connection with CFC dividends. We deem them to be constructively and actually granted under the State A, State B treaty. Your Honors, the main issue here is whether or not a CFC rule whose elements, as a matter of fact, are met, that if at least 80% of the shareholding in the company and that a rate of the rate of the tax in the CFC state is less than half of the tax and rate of the tax in state in the other state. Here, the two elements, as a matter of law, are met. First, because there's 100% shareholding in the subsidiary State B, and second, because the rate of tax in State B, the CFC state, is 4%, which is less than half of State A's corporate 20% tax. Moreover, there's an element of active business. In our briefs, we discussed the concept of active business income, and I would like to point the court to the 1962 congressional record from the Kennedy administration that presented the first CFC rules in the United States. It said, quote, only where it supports the State A interpretation where it says, quote, only where the property located in the United States is ordinary and necessary to the active conduct of the foreign corporation's business. They're substantially in the same trade or business. This has been this has been quoted in subsequent case law from the U.S. Tax Court as stating a group of assets can be treated as active conduct if there was goodwill in interpreting these assets. The argument here is in reference to whether international tax treaty is compatible with foreign-controlled corporations. The rules of foreign. It is difficult to assess this matter, and that's why, Your Honors, we'd like to draw from courts from all over the world, because there is no case law on point in State A that states whether or not controlled foreign corporations are compatible with tax treaties. Moreover, in accordance with the 1992 tax treaty that was the 1992 OECD commentary, there's no indication of CFC rules. There's no indication of CFC rules in the 1992 OECD commentary. One of the main issues is that the OECD commentary treats corporate entities as separate taxpayers for purposes of applying domestic tax laws and tax treaties. The problem is that the CFC rules result in attributing CFC profits to controlling shareholders. The shareholders at the parent subsidiary, even though such profits were never distributed by the subsidiary to the CFC. This is fundamentally contradicts the basic structure of the OECD model, which is the model that we follow for the State A, State B treaty. Indeed, there is no tax court with international jurisdiction to solve these issues, so it's important to look at the decisions from various domestic Supreme Courts. It's interesting to note that the ECJ tries not to answer issues of tax between countries. The OECD Model Convention specifically refers to CFC legislation in its commentary since the 1992 update. This is interesting considering that the first CFC was introduced during the Kennedy administration in the early 1960s. It was eventually passed by the Democrat-controlled 87th Congress under the Johnson leadership in the Senate and the Sam Rayburn leadership in the House in 1962. The 1992 commentary existed until 2003, where it was revised in part. The commentary in 1992 focused on the substance over form transactions and subpart F type rules, leading to transparent tax liabilities. There's two big cases on point. First, the Schneider case, and second, the AOE ABP case from Finland. I'd like first to discuss the Finland case and then the Schneider case to distinguish the two. So first, this Finland case involved a very similar situation where a Finnish company had a controlled foreign corporation subsidiary. The question was whether Article 7 of the 1976 Finnish-Belgium Treaty did prevent taxation from the Finnish parent company. It should be noted that the Belgian subsidiary did not have a permanent establishment in Finland, and the residency test effective management was based in Belgium. So we have an effective subsidiary in Belgium. The Finnish Supreme Court admitted that the classification of a CFC income attributed to its shareholders pursuant to the CFC rules was ambiguous. The Finnish Supreme Court ruled that CFC's rules are compatible with Article 7 of the treaty, and it stated these specific reasons. Tax treaties based on the OECD model, such as the Finnish-Belgium Treaty, do not aim to avoid double economic taxation, but only double juridical taxation. The Finnish CFC's rules do not result in the latter, so they don't result in double juridical taxation. The object and purpose of the tax treaties, for looking at purpose and object, is not only to avoid double juridical taxation, but avoid international tax avoidance. To prevent international tax avoidance is one of the main purposes. Tax treaties do not prevent the application of domestic anti-avoidance rules, including CFC rules. The large majority of OECD states so far, which is, I believe, 13, see the CFC rules as compatible with tax treaties. Taking into consideration the facts of this case, the only arguments the court may be considered appropriate are that the OECD respectively It's interesting to note that the Travaux Preparatoires from 1977 could be related of the OECD version, but the Finnish Supreme Court did not mention them. In international tax literature, Avery Jones, Michael Lang, and Professor Brugger all argue that there's possibility to claim that certain circumstances, newer versions of the commentary to the OECD model may be used to interpret older tax treaties. It may be, if the right wording in the newer commentary is only sensible to interpret of what was already written in older versions. Besides, it should be determined to what extent such a dynamic reference to later versions of the OECD commentaries is permissible under the constitutional law of the contracting states. We see no issue here with the constitutional law of the contracting states. One of the main questions is whether there's an unwritten abuse of law principle in the OECD rules specifically. The question is whether the purpose of a tax treaty is to prevent tax avoidance, just as it was determined by the French Supreme Court in the Schneider case. In trying to answer this question, we hold that the main purpose of the treaties as they were passed, using opposing counsel's arguments, not looking forward to the BEPS era, is primarily to prevent double taxation and not necessarily prevent tax avoidance. Although that would harm our argument as being the state aid tax authority that we want to prevent tax avoidance, but we're trying to convince the courts otherwise. So, with your honors, we respectfully submit this case. Please let us know if you have any questions. The state aid rests its case for the time being.